Good. Okay. Welcome, everyone. My name is Sylvia Novinsky. I'm the director of the North Carolina Pro Bono Resource Center, which is a program of the Equal Access to Justice Commission, chaired by Supreme Court Chief Justice Sherry Beasley. We are very excited to have you all here training. We're excited to provide this training for attorneys who couldn't be here in person. And this is all to get ready for our upcoming expunction clinic that is a partnership between a variety of organizations, including the Mecklenburg County Self-Serve Center, the Public Defender's Office, the District Attorney's Office, and the North Carolina Pro Bono Resource Center, as well as, I should not leave this group out, the Clerk's Office, which is incredibly, incredibly helpful to us. So what we're going to do today is we have two excellent trainers from the Public Defender's Office who are going to go over with you essentially what is expunction and train you for the piece of the clinic that is the in-person day where you sit down with a client and let him or her know whether they're eligible for an expunction. If they are, you'll go over, and Carson and Leora will talk about this more, what they would like to expunge. And then if you get that far, you will prepare the petition and it will actually be filed. The wonderful thing about this project is that it will actually be filed right then and there. The district attorney will be there to provide service. The clerk's office will be there to accept the petition. And so for many cases, that will be what happens. For some cases, they'll have an out-of-county issue and you'll prepare the petition for them to file. But we'll go over more of that. But we are incredibly grateful to you all being here. We're so grateful to Winston and Strawn for hosting this training and providing the video capability. We really wouldn't be able to do this without them. So thank you very much. So I will now turn it over to Carson and Leora. And they might, if you wouldn't mind, guys, introducing yourselves as you step up. Thank you.
Yeah, come on up. So this is my first time doing one of these video things, so I don't know where to look. So I'm Carson Smith. I'm at the Public Defender's Office. I'm gonna pretend it's not there. So I'm at the Public Defender's Office. Leora and I have been there for 3 years. We started on the same day. We interned in the same summer class. So we've been doing this expunction stuff together too. So it's been a need to kind of go through that. And what we're going to talk about today is pretty much everything that you're going to need to know in order to sit down with the client at the clinic, and not a client, but a petitioner, somebody that wants to get their record expunged, and talk them through that process and give them advice on what they're eligible to get expunged, and even if they're not eligible, kind of what that's going to look like as well. And then also filling out the petition, which is pretty simple once you've done it once. So we'll take you through all that, but I'll let Leora introduce herself as well.
So yeah, I'm Leora Moreno. I'm also with the Public Defender's Office. We're also, just again, really grateful to all of you for being here and volunteering your time for this project. We're really excited about it because our goal is to have this be a recurring clinic, hopefully about every 3 months or so, because there are just thousands and thousands of people who need expunction. So we're really excited about it. And basically, the way we've divided up this training is Carson's going to sort of take the first half, and that's going to go into the law on expunctions to try to give you an overview of the most common types of things you're going to see. And you guys are all going to get a packet as well. That's really, really useful. So we're going to cover a lot of what's in the packet, but not everything, so you can kind of peruse on your own time. And then I'm going to do the second half, which is a little bit more nitty-gritty, how this clinic is going to work. And then we'll go over some actual practice petitions so that we can all kind of get used to what it'll be like filling those out.
Yeah. And we've done this kind of presentation before, and people that haven't ever done expunction, it's pretty normal to be a little overwhelmed at first because there's a lot of requirements, and so and there's different types of expunctions, but you catch on pretty quickly once you actually do one yourself. And also, anybody you're sitting down with at the clinic has already had their record screened by somebody in our office that knows a lot about expunctions. And so they're going to have a cover sheet, and they're going to have a recommendation, and they're going to have kind of the evidence to back up their recommendation. So you're really just kind of looking at that, and then, you want to make your own independent determination based on the record, but you're going to have some guidance from somebody that knows what they're doing, or at least has been doing this for a while. So I say that just to don't stress out if we're going through this and you're like, I don't know how I'm going to do this. You'll get it. It's not too complicated once you've done a couple of them. So let's start by talking about what is an expunction. So an expunction is a legal process which allows you to get something on your criminal record taken off, eliminated. In North Carolina, and I think this is pretty common among all states, if you're charged with a criminal, you're charged criminally, that is on your record forever. It doesn't matter if it's dismissed. It doesn't matter if you're found not guilty at trial. It's going to stay on there. And so a lot of the expunctions we're going to be dealing with is people who have just a bunch of dismissed charges that are keeping them from getting work, keeping them from kind of getting where they need to get in life, because employers look and see the charge and they just say, well, I'm not going to hire this person because they've been charged with this. So the expunction is the way of getting whatever you've been charged with, you're eligible to get expunged, to get that off your record. And I just kind of went into this a little bit, but your criminal record dictates a lot in your life in terms of what you can do in terms of getting housing, employment, loans, benefits. And like I said, even if you have a charge dismissed, an employer or landlord, they might not really know how to read a record, so they're just going to see that there was a charge, and they're not going to either see that it was dismissed, or they're just going to say, well, you were charged with this, so I don't feel comfortable hiring you or renting an apartment to you. And so it can be extremely prejudicial and extremely difficult for somebody that has any kind of record to get housing, to get employment, to get that kind of thing. So we'll start by talking about how to get a conviction expunged, but most of the people you're going to be meeting with are going to be getting their dismissals expunged, which can make a huge difference for them. So how do you know if somebody can get something expunged from their record? It depends on a lot of stuff. It depends on when they were charged, depends on what they were charged with, depends on what was the disposition. So was it dismissed? Was it a conviction? And it also depends on how much time has passed since that person was convicted or since that charge was dismissed. And so what we'll learn about is how to look at these records and look at the pieces of information that you need to make your decision on whether or not somebody is eligible for an expungement. I wanted to take a step back. We work in criminal law every day, so we're very familiar with how criminal statutes are structured, and it's helpful to have a bit of an understanding of that when you're doing this, because whether or not something's a felony or a misdemeanor matters, what kind of felony matters, what kind of misdemeanor matters. So I wanted to just do a general overview, so when we're using terminology, you have a little bit of a framework that'll help kind of guide you as you're analyzing these records. So felonies in North Carolina, the most serious felony is an A-class felony. And Kathy, correct me if I'm wrong on any of this, because right now I don't practice felonies. But my understanding is that the Class A felony is the most serious. The least serious is a Class I felony. So you're going to hear that a lot of H and I felonies are eligible, convictions are eligible for expunction. That any A through G felony is not eligible for an expunction. An A through G conviction is not eligible for expunction. So just so you know, it goes from A to I. H and I, the two lowest, are the ones that you're going to be dealing with that might be eligible for expunctions. With misdemeanors, there's four classes of misdemeanors. There's A1, there's 1, 2, and 3, and that's A1's the most serious, 3 is the least serious. A1 misdemeanors are not, convictions, again, I'm only talking about convictions with this, are not eligible for expunction. So if you get, you see a misdemeanor, what you might need to do is you might need to look up the statute, because the statute will tell you what kind of misdemeanor it is. And then if it's an A1, you're not going to be able to get that conviction expunged. 1, 2, and 3 might be eligible for expunction depending on what kind of conviction it is. Infractions are traffic-related charges. They're not serious. They're like a small speeding ticket or rolling through a stop sign. Those are not eligible for expunction, and I think the reason for that is probably because they just aren't serious enough that our legislators are going to take the time to pass a statute that allows for infractions to get expunged. Judges are going to be signing off on these things. I think there's just a consensus that it's just not serious enough for those to be eligible for expunction. There is some confusion though that you'll find yourself in. So I want to make a distinction between an infraction and a traffic charge. So a traffic charge could be a felony, it could be a misdemeanor, it could be an infraction. Traffic just means that it's driving related. So a DWI is a traffic charge. A speeding ticket is a traffic charge. As for how serious it is, it could be felony, misdemeanor, or infraction. So when we're going through these records, you might see things that say traffic. That just means that it's driving related. It doesn't really tell you whether or not it's a felony or a misdemeanor or infraction. So that's something you're going to have to look into. Am I making sense on that? Okay. So I think it's important to understand why there's such a need for these kind of clinics. Only within the past, I think it's 6 or 7 years, have convictions even been eligible to be expunged. So expunction law has really developed over the past 6 or 7 years. And it used to be that you had to wait 10 or 15 years after you were convicted to even have an opportunity to get a felony or misdemeanor expunged. Again, a conviction. However, at the end of 2017, 2018, they changed that law so that you only have to wait 5 years now before you can get a misdemeanor conviction expunged, 10 years for a felony conviction. So that has brought more people into the pool of people that are eligible to get their convictions expunged. Another way that the law that updated in 2018, another way that it has expanded the amount of people that are eligible for expunctions is it used to be you could only get, if you had dismissals, you could only get dismissals that happened within 1 year expunged, and you could only do that once in your entire lifetime. So you kind of had to pick. If you had dismissals from the 80s, the 90s, the 2000s, you got to pick 1 year and you just got those expunged, and that was it. You couldn't do it again. Now you are eligible to get anything that's on your record that is a dismissal expunged, and you can do it as many times as possible. So you could get something expunged from a couple years ago, and if you get a charge tomorrow, that gets dismissed, then you could get that expunged later on. So that's where you've seen a huge increase in the number of people that are eligible for expunctions is with these dismissal, the expansion and this dismissal expunction statute. And so that's what we're going to be dealing with a lot in the clinic is people that are coming in with a ton of dismissals and wanting to get all of those expunged, and now they're eligible to do that. So let's dive into some of the types of expunctions. We'll start with conviction-related expunctions. The broadest category for a conviction-related expunction is nonviolent felony or misdemeanor convictions. And so there's some criteria that have to be in place for you to be eligible to have a nonviolent misdemeanor or felony conviction expunged. So the first thing is that you can't have any other convictions on your record. So this is where we're going to get into how narrow it is for eligibility when it comes to getting convictions expunged. So if you have a conviction on day 1 and you have a conviction on day 3, you can't get either of those expunged because you have more than one conviction on a different day. The only caveat to that is that if it's a traffic conviction, so that's a driving-related conviction, that's not going to exclude you. That's not going to count as a other conviction for purposes of eligibility. So if on day 1 you get a DWI and on day 3 you get a marijuana conviction, that marijuana conviction is still eligible for expunction, it's not getting knocked out by the fact that you've got a DWI conviction on day one. Even so, even if you do fall into this narrow category where you've got this one conviction and that's it, and other than that you don't have any other convictions, if it's a felony conviction, you have to wait 10 years from the date of the conviction to be eligible to get that expunged. If it's a misdemeanor, you have to wait 5 years. You have to have completed your entire sentence. You can't have any pending charges at the time. And you can't have previously gotten a conviction expunged under this statute or under any kind of conviction statute. So when it comes to getting a conviction expunged, you get one of those in your lifetime. So you're going to get one shot. So sometimes that'll come up in the clinic there are very narrow circumstances where you have two convictions and one of them can be expunged. You're going to have to advise your client on your recommendation on which one should you try to get expunged. So that's not going to happen often, but it is every once in a while it will come up. And so there's a same session of court exception. That just means that if you have multiple convictions, but they all happen in the same session of court, so on the same day, or maybe the same week if it's in felony court. Do we know about that?
I think that's right.
Yeah. Because the session of court in felony court is a week long. But if it's a week long for felony or it's the same day, usually you're going to see same day. Because normally when people do plea deals, they're going to plead to everything on the same day. All of those count as one conviction. So those, that means that you could, I don't think you could you get all of those potentially expunged? I think you could because it counts as one conviction, right?
Well, I think they would all have to individually.
Yeah, each individually would have to qualify, but potentially you could get all of those expunged. So in our practice, if we are working out a plea deal and maybe our client has a different attorney on some other cases, we really do try to get that so that the plea is on the same day, so that is something that potentially they could get expunged in the future. So these are all kind of boilerplate qualifications that are, I think, pretty straightforward. The nonviolent criteria is the one that I'm going to focus on because that's the one that you're going to be doing the most kind of legwork to figure out, is this a nonviolent conviction? So on its face, nonviolent, it would seem like, well, that's just the opposite of violence. So we're looking for, is there an assault? Is there a robbery? Something like that. But nonviolent is actually more expansive than that. So a conviction is not nonviolent if it's a Class A through G felony or an A1 misdemeanor. So it doesn't matter. So, for example, A1 misdemeanors, a lot of them are violent-related charges, like assault on a female, assault inflicting serious injury. But there are ones that aren't violent at all. For example, food stamp fraud is an A1 misdemeanor. That is not eligible just based on the fact that it's an A1 misdemeanor. So you do oftentimes have to look at the statute just to make sure, is this an A through G felony or is this an A1 misdemeanor? Because if it is, then you're not going to be able to get it expunged. Assault cannot be an essential element of the offense. So that's something where you might want to look up usually assault is going to be in the title of the charge, so it shouldn't be that complicated. But something like a robbery, assault is part of a robbery. Am I right on that? So, but you might want to look up that just to see the language in the statute. It should say something about assault. And then the drug ones get a little complicated. And when you're at the clinic, if you get to this and you're not sure what to do, just grab me or Leora and we'll kind of go over it with you. So if you ever get something where like, I'm not sure if this is eligible or not, is this, one of these drug convictions that is or isn't, then just ask us and we can help you out. So any felony offense that involves meth, heroin, or possession with intent to sell or deliver cocaine is not expungable. Any kind of conviction on those grounds. So what that means is possession of cocaine might be eligible. Possession of marijuana, possession with intent to distribute marijuana might be eligible. But if it has anything to do with meth, anything to do with heroin, or it has to do with distributing cocaine, selling or delivering cocaine, it's not going to be eligible for an expunction. And then there are various felony breaking and entering offenses that are barred. This is the packet that we're going to give you today and that you're going to have at the clinic is actually going to give you the statute numbers for what is barred, so you can just look that up. Just for brevity's sake, I put it as that in here, but in the packet you'll have that information. Yeah, do you have any questions? And I should have said at the beginning, if you have any questions, just ask me, interrupt me throughout. So a different type of conviction expunction statute is one that's related to, there's actually two that are related to the age, somebody being under the age of 18 at the time that they got charged, or excuse me, at the date of offense for whenever this happened. So this statute relates to misdemeanor convictions when the petitioner is under the age of 18 at the date of offense. And so one thing that is, there's a couple things that are distinctive from this and the statute we were just looking at. One is that it's more expansive with what kind of misdemeanors are eligible. So if you're under 18 and you've got an A1 misdemeanor, it wouldn't be eligible under that other statute because it's A1 misdemeanor, but it could potentially be eligible under this statute because this does not limit that that criteria to everything but A1 misdemeanors. Additionally, it can be a nonviolent or violent misdemeanor. So, for example, an assault, if it's got assault, if they're under 18 at the date of offense, then that could be eligible for an expunction, whereas it wouldn't be eligible if they were over 18. They can't have had any previous convictions before the date of offense, and they also can't have any subsequent convictions within 2 years, I believe it's of the conviction date. So this is also more expansive in the sense that whereas the statute we just looked at, you couldn't have any other convictions at any time in your life other than traffic. With this, it's if you have a conviction at 17 and then you have a conviction at 22, that one at 17 might still be eligible. So that's an instance where you might be talking to somebody about which one you want to get expunged. And so this is much more expansive. The timing is better. You only have to wait 2 years from the date of the conviction, whereas you would normally have to wait 5 years if you're over 18. And so it's critical when you're looking at these records to look at how old the person was when they were charged, or how old they were on the date of offense, which is the most important part. Because on your first impression might be, oh, conviction, here's a conviction, here's another conviction. That means they can't get either of these expunged, but you just need to make sure to look at how old they were because they might be eligible under this statute. There is a conviction statute related to felonies that are committed before your 18th birthday. However, there are a couple limitations in this statute that weren't in the previous one dealing with misdemeanors. So, for example, you can't have a nonviolent felony. So we're talking about those same things that were considered nonviolent under the original expunction statute. So, for example, if it's an A through G felony, even if it was committed before your 18th birthday, you're not going to be able to get it expunged. So really, we're just dealing with H and I felonies that are nonviolent. So even if it's assault related, it's H or I, it's going to be out. So the benefit of this statute it doesn't relate to the actual charge or the conviction itself. It relates to time periods. So in this one, you can't have had any prior misdemeanors or felony convictions before this one, and you can't have any subsequent misdemeanor or felony convictions within 4 years after the conviction date. So here's another example where you're 17 years old, you get convicted of a nonviolent felony, and then 6 years later you get convicted of another misdemeanor or felony. You might still be eligible to get that felony expunged under this statute, whereas you would not normally be able to because you have convictions on different days. There is a requirement on this one that it says that the person must have performed 100 hours of community service and have either a high school diploma or a GED. Do you know if that's waivable? We haven't actually had anyone eligible for this in the clinics yet.
I don't know if that's waivable.
So that's something that, when they come and they find out that they're eligible under the statute, there might be some legwork that needs to be done before they're actually able to go forward with the petition because of that last requirement. So that's something that if this comes up, just talk to us and we'll figure it out. Darwin, do you know anything about this in terms of if that is a hardline requirement that they have to show that they've done 100 hours of community service and have high school diploma or GED? Okay.
It is. It's one of those provisions that have to be met.
Okay.
Prior to that.
Okay. Yeah.
Looking at the statutes for the nonviolent felony for anyone in the nonviolent felony under 18, it looks like the B&E is not classified as nonviolent if you're under 18.
Okay.
Is that correct?
So are you getting that from the packet?
Yeah.
Okay. So it's got in the packet, I'll go ahead and give you all the packets now, just so you can reference that. This is what is kind of your Bible that you're going to have when you're in front of with a person that's trying to get the record expunged. So what Kathy's saying is the nonviolent definition under this statute is not as expansive as the one under the original statute we were looking at.
Yeah, it doesn't include the B&E and the burglaries, which, we have a lot of 16 and 17-year-olds charged with B&Es. So,
yeah. So it doesn't. So somebody, if they have a B&E conviction and the date of offense is before their 18th birthday, then they might be eligible under this statute, whereas they wouldn't be eligible
if they were over 18.
If they were over 18.
Right.
Just
That's
because
what
of the.
It looks like to me.
Okay. All right.
That would be great.
Yeah.
Yeah.
Any other questions about this one? So the last one that we're going to cover for conviction expunction statutes is drug convictions under the age of 22. And so this is another one where you got to pay close attention to how old the person is on the date of offense. So this is a conviction for a misdemeanor possession of drugs, which is only going to be marijuana if it's a misdemeanor, or paraphernalia, so anything that's used to use drugs, or a conviction for felony possession under this particular statute. That's North Carolina General Statutes 9095A3. And that is a statute that is related to, Kathy, do you know if it's related to possession? I think there's actually a note in the...
Yeah, I'm reading it right now. It looks like it says individuals convicted of felony possession of 1 gram of less than 1 gram of cocaine prior to 2012 are eligible.
And then I think after 2012, there wasn't a limit on the amount of grams. So I think it is only cocaine, and probably maybe a marijuana level, marijuana possession that's just a higher amount that kicks it up to a felony. But just look, if you get something, you find somebody that's under 22 and they've got some kind of felony conviction for possession of drugs, you would just want to look at this statute and see if that statute applies. It also should be pretty simple because the statute that they're cited as violating should be the same statute. So that's probably the first place you want to look is on the actual record itself. It'll always show you what statute they are accused of violating. And then they can't have any prior or subsequent felony convictions, misdemeanor convictions under Chapter 90. So that is any drug-related conviction, misdemeanor convictions, or any convictions related to controlled substances. So what would this mean? This would mean if they have like a shoplifting conviction, misdemeanor conviction, or some kind of small petty misdemeanor that isn't drug-related, they could still be eligible for this even though they have another conviction. And at least 12 months have passed since the conviction date. So this is one that you're going to see very rarely, but it does come up. And so if you're at the clinic and you see this, you see somebody's under 22, they've got a drug conviction, you could probably exclude them pretty quickly if they've got other convictions that fall, if they have any other felony convictions, they're not eligible. If they have any drug-related misdemeanor convictions, they're not eligible. So you can probably exclude a lot of people pretty quickly, but if they seem like they might qualify, then you can just let us know and we'll kind of go over it with you. Any questions about that statute? Okay. So this is the one you're going to be dealing with the most. This is charges not resulting in a conviction. So most of the records you're going to see are going to have predominantly dismissed charges, really dismissed charges. You might see some not guilties in there, but the most criminal charges are disposed of via dismissal. So you're going to see a lot of those. And so the only criterion to whether or not somebody is eligible to have a dismissed charge or a not guilty expunged, the only question you need to ask is, do they have any felony convictions on their record? If somebody has a felony conviction on their record, they are not eligible to get dismissals expunged. It's kind of ridiculous because what does that have to do with the fact that their other charges were dismissed? And we're very optimistic, I would say cautiously optimistic, that the legislature in the near future is going to change the law so that that's not something that's barring people from getting dismissals expunged, and maybe even where when people do get charges dismissed, they automatically get removed from their record, which is really how it should be, because you shouldn't have that held against you if you have something dismissed. So when you're going through, you're going to get some records that are pretty big, and it might be because they're big because they got a lot of dismissed charges. It might be because they have convictions. But as you're going through, I always recommend just skimming through the record first and just making a note to see if they have any felony convictions, because if they do, then they're not eligible to get their dismissals expunged. Now, I say that, but there is a scenario where that felony conviction, they've only got one, and it's eligible for an expunction under one of those conviction statutes. If they are eligible under one of those conviction statutes, you can get that felony expunged, which clears up the bar on this statute and then allows them to get all the dismissals expunged. And how we can do it, we don't even have to do that in two different sittings. You can submit two petitions. You can submit a petition to get the felony expunged, and then you can submit a petition for the dismissals, and the judge is going to understand what you're doing there, and the clerk's going to understand what you're doing there. So, I just want to caution you, if you see a felony conviction, it's not automatically that they can't get their dismissals expunged. So you just want to make sure you do your analysis on the conviction before you decide that. But what I don't want is for you to be spending all this time filling out paperwork when at the back of their record they have a felony conviction that just bars them from getting any of their dismissals expunged. Let's see. So that's the only criteria, which means that it doesn't matter if they've had a prior expunction. It doesn't matter how many dismissals they have. It doesn't matter over what period of time. They're all eligible to be expunged. And so this is where you can take some time with the petitioner is filling out the paperwork where somebody has, I think at our last clinic, we had somebody maybe like 50 dismissals that were eligible. And so it was a lot of work, but it was pretty incredible to see, we just almost eliminated her entire record. And, an employer gets that thick of a record, they're going to judge her for it no matter if they've all been expunged, no matter if they're all dismissals. So that was pretty awesome. So we're going to talk, there's a note there at the end about filing fees. We're going to talk about that a little more when we get to the forms. Does anybody have any questions about this statute? Okay. I'm going to briefly touch on certificates of relief. You don't need to know too much about them because we don't actually do them at the clinic. Certificates of relief are a document that allows a landlord or an employer to either rent to somebody with a record or hire somebody with a record without being basically shields them from negligent renting practices, negligent hiring practices. It's just a document that allows them to rent to somebody they otherwise wouldn't be allowed to rent to. It's not something that is very useful unless you have a relationship with the person. They're like, I wish I could rent to you, but I can't. And that's when it's something that comes into play. The only time I've ever seen it is somebody that she worked for a fast food restaurant, and they wanted to promote her, but they couldn't promote her because of her record. And a certificate of relief allowed them to promote her. So she actually came to the clinic I was working at that time and said, this is what they say I need. So it's something that if somebody knows about it and they need it, that's when it's useful. But on the whole, it's not just useful necessarily for somebody to have. The reason we don't do them is one, they're pretty time consuming. You also have to, I believe, have a hearing, and you have to have an attorney. And we aren't really capable of going to hearings for the people in the clinic and helping them out down the road with that. So we have made a decision not to do certificates of relief. So if somebody asks you about it, you're welcome to tell them a little bit about it, but just let them know we don't do that through the clinic. I think it's you.
No questions so far, really?
Is the only the dismissals you talked about getting the prior felony expunged first and then doing the dismissal? Is there any other statute where any other category where you can do that, where you can sort of knock out one in order to qualify for another?
So I can't think of one, and correct me if I'm wrong, and the reason is that with all the conviction statutes, you get one, and that's it. So you might be thinking of like, under 18, knock that conviction out, and then I would be eligible for something under the more expand or the over 18 one. But you only get one, so it really, I think, is just this kind of situation because you get unlimited expunctions for dismissals, but that's it.
And the one other question I have, and maybe you're going to get to this, is like, to what I just expect maybe we'll hear this question from somebody. To what extent does the expunction of a conviction restore like voting rights or gun rights that were lost as a result?
That's a really good question.
Yeah, Sylvia, Darwin, do you know?
So,
go ahead. Yeah.
Well, so for the gun rights issue, honestly, we should talk to my husband because he's just helped somebody get their gun rights back after an involuntary commitment for substance abuse that was like 20 years prior. But there can be some issues if it's for out of state because some states won't take it off the national register, the national issue, and there was he did the first case here. So if it's out of state, we can ask Mike. I don't know about here.
I mean, it's not.
Yeah.
I mean,
It's
a really good question. I mean, with voting rights in North Carolina, if you have a felony conviction and you're done with your sentence, you should be eligible to vote again anyway. So hopefully this wouldn't actually be the deciding factor for that. But
I mean, it's supposed to act if something is expunged.
You're supposed to be able to go ahead and
It's as if
sign up to vote. You are eligible to sign up
right.
to vote.
It's basically supposed to be this legitimately never happened.
Yeah.
If you were taking the stand for some reason and were asked if you had any convictions, you can say no, and you would not be lying. The only issue is that the DA's office would be able to see if you had a conviction and it was expunged, and then you got charged with something a few years later, the DA's office would be able to see that you had a prior conviction that was expunged, but nobody else in the universe would, basically.
Does the expunction so if you get a conviction expunged or even a dismissal, does it remove the arrest as well? Because I've had a pro bono client previously who was never actually, she wasn't charged, but the arrest itself was the issue. That she, from her perspective, she was arrested, then she was released, and she answered a question in an interview that was, have you ever been all of these things? And she said no, and then we had a probate officer who came back and was like,
well, actually she was arrested, because the arrest itself was still sitting on her record.
It's really interesting.
How long ago was that?
It was, well, one, it was in California,
Oh,
but
okay.
but that happened. I worked on that case was 2012 or 13.
I just, when you look at a record, there's no category or place to put arrested. Like it's maybe in North Carolina, it's just not something
Yeah.
we record. It's the charge is what's
Yeah,
there.
I mean,
Yeah.
their mugshot
Yeah, that's what I thought you were
is
talking about.
still
the
going
mugshot,
to
yeah.
exist. Unfortunately, that is not something that we can get rid of.
Yeah. Okay.
And there are people trying to work on that issue as well.
Because that's also prejudicial.
Third
so-
party.
Yeah.
Right.
Yeah.
Yeah, it's just because, some applications will ask, have you ever
Right.
been charged, convicted, right? But if they ask if you've been arrested and you have an expunction, it does that, like, what is the client supposed to answer?
That's a great question. So I will say that I don't really know how often that seems very unusual to me to have someone who's arrested and not charged with something. I don't think that happens very frequently, but I do know that one big area where that might come into play is immigration stuff. And I believe that a big caveat to expunctions is immigration law. So if someone has been charged with something and then it's expunged, I believe they still have to say they've been charged with something actually for federal immigration purposes. Yeah.
And so I think it's more of a function of CMPD and what they put in, or arrest processing and what they put in, because on the form and actually on the record, there's a spot for arrest date. And that's what they will have on there, because when you look at the form itself, it'll ask for the date of arrest. You're filling out the expunction form itself. So all those items are on there. So that whole
So it should
everything
group
goes
it,
away.
yeah. Okay.
So for that particular charge or that particular conviction, everything related to it goes away.
Gotcha.
These are all really good questions, though.
And as far as gun records, it is a hearing. I've had a couple people have to do that to try to get their, and that's even here. I've had a number of people try to get they apply for a permit in North Carolina. The Sheriff's Department rejects it. They have to then have a hearing in front of a judge to have those rights restored before the Sheriff's Department will provide them with a permit.
So you said the Sheriff's Department is involved in this project, correct?
Yes.
So are there plans for the sheriff to smooth that process between the expunction and the Sheriff's Department if they're on board with this?
So where we're at right now is we're dealing with the captain that runs the courthouse because we have to have the Sheriff's Department is supposed to charge us for off-duty time at like $29 an hour, but because we're partners in the courthouse, they don't charge us for that. So we haven't gone outside of that purview yet to talk about other things that affect, but having their captain on board is a start to hopefully the sheriff himself coming to a meeting and we'll talk about how it spreads out and how it affects other areas. Because that is one area that affects, if it's off, is there a way to streamline the process that once the record comes back, the judge does the final signature and the Sheriff's Department has a copy of the record being expunged, what does it take for them to take that out to say, now when they file for a permit, they're able to just get it? Or does the court still want to have some part in that process to look at anything else? Because the AOC, outside of the DA's office, the AOC is the other entity that will hold that record.
Administrative officer.
Administrative officer of the court. So a judge could effectively say, let me see, Carson Smith's, entire record. And see, because another part of it is they mainly do that for DUI. So if you're at one level on a DUI, you get expunged, they don't want you to come back and say, well, hey, this is my first time. No, they would look and see that, this is actually your third. So there's some places where it's held, but it's only looked at for certain reasons, and that might be another reason why they look at it, just to look at anything else before restoring those contracts.
I'll do that.
You do this. Okay, so we're like running a little bit low on time, so I'm just gonna this is not super substantive, but, and Sylvia and Carson kind of already mentioned some of this stuff, but basically one of the really great things about this clinic is that when everyone comes in, if they're eligible to get something expunged, then you're gonna help them fill out their paperwork. If it's a Mecklenburg County dismissal or conviction, they get to go right up to the DA, get it notarized, serve the DA. All the petitions go to the clerk. The clerk sends them all off to Raleigh at the same time. That's where the SBI, which is like the national background check, happens, and all the other stuff happens. And it just kind of expedites this process. So it's like a really nice one-stop shop for all of these individuals. And I just wanted to reiterate, all of the law that Carson's gone over is definitely stuff that we want all of you to be familiar with and somewhat comfortable with, because you're the person sitting down with these individuals and giving them legal advice. But that said, we've already had an attorney screen the record, and again, there's going to be a cover sheet. We have example cover sheets and example records that we're going to pass out to all of you so that you can get a little bit comfortable with what those look like. So basically the cover sheet is just designed to kind of give you a little bit of a head start. Like, it's going to say this person is eligible under 15A146, and that would mean this person has dismissals or not guilties that they can get expunged. And then you're going to go through the record and just basically confirm that that is accurate, because obviously everyone makes mistakes sometimes, so you're kind of the second set of eyes. And then you're also the person who's going to explain, particularly when they're not eligible, this is the really not fun part of this clinic, why they're not eligible. That's something that often people really want to understand. Like, if I'm not eligible, why? And sometimes they will have heard that they will be from a friend or whatever, and they just don't get it. So having them understand why they can't get something expunged is really important for them to have some closure, maybe. And then I just included another couple things to help you guys out. Infractions you'll see listed when, like, every charge has a number associated with it. In that number, it'll be like, for example, everything that happens in 2019 starts with 19, and then it'll be like CR or CRS. Doesn't matter, that CRS has to do with indicted felonies, but CRs and CRSs are what we care about. If it has an IF, that means infraction, so we ignore it. Infractions we don't care about, okay? And then another thing just to note is that we will get some people coming in who have pending charges. Those people cannot go through this process until they've resolved those pending charges. It should say that on your cover sheet if that's the situation. But you'll also see in the record, it'll have like charge, arresting date, offense date, all that stuff, and then it will show that it is not yet resolved. So that's how you know that they have pending charges. And sometimes people don't know they have pending charges, so that's important to tell them. And then when it comes to out-of-county stuff, whether it's convictions or dismissals, what we're able to do is basically help people fill out their paperwork so that they are kind of ready to go through the process in whatever other county it is, but we can't actually help them with the filing process. So we have the ability, we also will have people from the clerk's office who are there to help you out. Sometimes people have dismissals from like 5 different counties, and we'll have someone helping you out with that paperwork, and then we kind of just let them leave with the petitions that are ready to go and explain to them, you need to take this to the appropriate courthouse, and kind of go from there. Does that all make sense? Yes, Celia.
So I also just want to reiterate that it is the person, him or herself, the petitioner, him or herself, who is bringing the paperwork to be filed. You're actually not, your representation, if you can call it that, your help ends before that. And so this is a limited scope opportunity where you are helping the person understand why he or she is or is not eligible, help them prepare the petition, but they are the ones who are filing the petition.
So they're the ones actually signing it, and Sylvia has all of that paperwork for you to go over with each person once you're actually at the clinic. It has kind of a script for you, so we'll help you with that. So just a couple of questions that come up sometimes. I don't know if you all know what PJCs are. They're a very weird thing in North Carolina. They stand for Prayer for Judgment Continued. It basically, the best way I explain it, I think, is it's a conviction with no sentence attached to it. So it's like you're guilty of this, but we're going to be really nice to you and not punish you at all. They come into play a lot with traffic charges because they don't suspend your license. So you might see PJC in a record. Really, all you need to know for the purposes of this is that a PJC is a conviction. So if someone has like a driving with a revoked license, PJC, it's still a conviction, but that said, it's a traffic conviction. So it won't necessarily, because if you remember back to those statutes, like traffic convictions are usually an exception to not barring you from an expunction. So it's just something to keep in mind, PJCs. Yes.
But correct me if I'm wrong, if it's a PJC on a regular criminal case like a marijuana or something, it's not expungible, right?
No,
or it is expungible.
It is, but it's a conviction. So
Okay.
if you have like a PJC on a marijuana case and that is their only thing, then they can get
They
that.
can get that.
Mhm.
Okay.
But it will count as their lifetime
Right.
one. Yeah. And then another thing that we want to make sure you're aware of, a lot of times people get charged with a felony and then they plead to a misdemeanor. When that happens, you'll see, maybe it exists on one of these records, it'll say like charge, felony, this is an example, charge, felony larceny. And then below that, it'll show conviction, misdemeanor larceny. So in that case, you know that this person was originally charged with a felony, but then they were convicted of a misdemeanor. If that misdemeanor conviction is eligible to get expunged, something that you want to make note of is that the felony charge, even though it's kind of dismissed because it was really amended, so it's a little bit of a weird thing, but they can get that felony charge expunged as well as that misdemeanor conviction if that conviction is eligible. So what we will note on the petition is we were told by someone that they recommended putting arresting charge only, basically meaning to note for whoever's looking at this, like a judge, that this is a charge that then led down. Make sense? Okay. And then the traffic charge and conviction question, that's a really complicated one, to be honest, but basically what makes something a traffic matter is if it's under Chapter 20. Chapter 20 is where all the motor vehicle offenses live. Carson went into the fact that this can range from, this can be like a felony motor vehicle, like manslaughter, to a speed. So it has like a huge range. You will see a lot of driving with a revoked license. You'll see a lot of DUIs. DUIs are never expungible. But basically, if it's Chapter 20, that is how you know that it is traffic related. And if you have any questions about it, again, just grab us at the clinic. We will be there. Okay. So we've kind of already gone over this stuff, so I'm just going to go to this. So, do you want to hand out the stuff?
Yeah, sure.
So
I'm going to give out a record, and I've got 5 or 6. If y'all can group into 2s, and just take a look at that as she goes through this, and then we'll actually string the record together.
And if you want to talk.
So all of you are getting some practice records to look at, but so here we have kind of another practice one just so you can see what they're going to look like. So at the top of the record, you can see it shows you what county that we're in. So here we're in Cabarrus County, and then the case number next to it, you can see starts with 17, so that means it was 2017, and has a CR next to it, so that means we're dealing with criminal and not infraction. So that's kind of what we're looking at, and then right below that, you'll see the case information. This tells us it was disposed in district court. It tells us the offense date was May 27th, 2017. And then we don't care about the below thing. And then under defendant, it tells us the defendant's name and their date of birth, which we obviously care about date of birth because that is how we're going to do our math to know if this offense might have fallen into one of those age-related categories, okay? Okay, date of offense, date of birth. So these are things that you're going to want to be paying special attention to. Then below, it'll tell us a little bit of information about the actual charge. So this is a no operator's license. It says traffic next to it. And then under law, you can see it says GS 20 7A. So that's a chapter 20, but it will also say traffic, which is very helpful. No operator's license is disposed. It shows dismissal without leave by DA. That means it's been dismissed. And basically, this is going to be a dismissal. So unless this person has a felony conviction on their record, then this person can get this dismissal expunged. This is the same defendant. This is a Mecklenburg County one. It's from 2007. So we have an offense date of September 16th, 2007. Okay, so here we have an actual conviction. So it tells you that it's a misdemeanor. It tells you that this person was charged with intoxicated and disruptive, and unfortunately pled guilty to intoxicated and disruptive, which is ridiculous, but maybe they didn't have a lawyer, or they had a really bad lawyer. And they, so basically, things you're gonna, care about. Intoxicated and disruptive, what kind of class is that, right? Because it's a misdemeanor. Is it going to be, what class misdemeanor? Does it fall into an A1? Because that's going to, luckily it's just not, it's very not serious. And it was in 2007, so have at least 5 years gone by? Yes, great. Is this the same person or different person?
No, so this is,
I wanted to give an example of a misdemeanor conviction, and the next one is a prayer for judgment.
Okay, so let's just say that these two things were this person's entire record. We have great news for them, right? Because they're going to get this stupid conviction expunged, and they can also get their dismissal expunged. So they can get everything expunged. Does that make sense? Okay, great. And then this is an example of a prayer for judgment, which is exactly what Kathy had asked about. So this person, we're just going to say this is a different person, got charged with possession of marijuana up to ½ ounce. And that is a class 3 misdemeanor, so we know that that's okay. They got a prayer for judgment, which means maybe the judge thought this was not a big deal, or they did some kind of whatever, it doesn't matter. But they pled guilty, judge gave them a prayer for judgment. So this happened in 2000. So if this is this person's only conviction, then they will be eligible to get this expunged as well.
Since this is the same person,
Yes.
and if we were looking at this and they can only get one of these expunged, what would you recommend?
Great question. So unfortunately, because just me doing a little bit of math, I don't believe this person's going to be able to get either of these expunged, because I don't think either of these happened when they were young enough.
Gotcha.
Which is a bummer. What's the other one? He's 78, born in 78.
Yeah, so he's
Sometimes
41.
you want to go by date, so you want to do the more recent one.
Okay.
With this,
They're both so dumb.
they're both dumb.
God.
They're both kind of dumb. like equally dumb.
And
so.
I think you can ask your petitioner, like, do you have a preference for which one of these?
Yeah.
Do you feel like one of these is getting more in your way? My gut tells me get rid of the marijuana, just because drugs, even though, I'm not going to get into it. But like, I think that as a class, drug convictions are more harmful than alcohol-related convictions. So my gut tells me to do that, but I think you can leave it up to the petitioner and say, like, do you have a preference? Do you feel like one of these is harming you more? Mm-hmm. Yeah. But yeah, unfortunately, this person is out of luck. So.
Do you want to? Why don't y'all go ahead and look at the record? No, let's do this. Kind of go. Okay, now we're going to do the petition. So yeah, just give them one. Okay, cool.
Told us that the PJCs can be expunged.
It didn't happen when she was under 18 too.
Oh, it's cool to be right about something.
Did just look up a blog post. I will tell you that Jamie Martin says that even though judges think they can't get expunged, they actually keep. So that's probably what Tony. That was from 2010. So
Well,
I'm willing to accept that.
Two different ones. Damn, girl.
Charge not resulting in conviction.
So,
Oh, no, that's right.
like dismissed. So this is dismissal without
So there's not something that just says convicted there, that just means there was no.
Right. Yeah.
Okay, so these could dismissal.
Those were dismissed, yeah.
Because as long as it's dismissed, it doesn't. Okay. As long as it's like not a.
As long as they have no felony convictions.
These are not what our records look like that we pulled, so I'm like, I think so.
Dismissals can't have a felony.
So then, that's.
yeah.
Yeah, that's it.
Okay, for a federal charge.
So this one gets dismissed.
Another traffic.
There's no conviction. This one.
Right. Where Donnie. She was convicted and got.
Pleads guilty.
I'm very. What about the,
No, that's two different things.
And then she violated.
I know that we talked about this on Monday, but,
I really don't know.
Now she's
okay. But I listened to it.
Unless we can expunge them simultaneously.
Charged with this, moved to this.
So it's a non-violent felony.
Deals, yeah.
Yeah.
It's under.
So that's annoying.
Another question.
Not a.
Are these gonna just say possession schedule 2, or are they gonna say
So
possession?
in sum, we have
Possession was the second part.
felony
Because
conviction.
like meth is a schedule 2 as well. So are the records, they should specify the drug? Okay.
Okay.
Well,
That doesn't.
pills.
No, that's for.
It's value of the property.
I don't.
I'm sorry.
Yeah,
That's only.
I don't know what that is. Like,
Oh, wait, but that's only.
is that HRI or is it?
Yeah, all simple possession is an HRI.
15A
Also,
for 145.
HRI. So I think that.
But what is it if it's less than
They're not meth or heroin.
But they also that.
less than $100,000?
But they're in the same schedule, right, that's the problem.
Well, and it's interesting is it says not meth, not heroin,
Well,
or not
just-
possession of to sell distribute cocaine. So that seems pretty like that's it. So it's out of that.
Yeah, so you can get a sale of marijuana,
And this is a class C,
But not
you
a-
said?
Well, it depends on how
not
much
a
it was.
PWISD cocaine charge.
It's like a choice.
Yeah.
Okay, great.
See if it's
You guys cool,
Next one we
okay.
have is.
Sorry, guys.
Yeah.
I didn't ask this to the whole group because I knew.
Let's do
Well, the thing is,
12,
yeah, you probably would be a better person to ask that question if you just kind of looked at it than we are because we don't do that kind of.
Yeah,
Thanks.
it's been a long time since I've looked at drug cases.
Felony and misdemeanors.
felony.
It doesn't matter, right?
I honestly think
So this one,
give out petition
Yeah, I
and
think so.
more information required.
Okay, so I'm trying to figure out you can use the sheet, which time and
Okay. So then she's got deferred proceeding, deferred prosecution, dismissal. So this,
Oh, wait,
are these the same?
What is it?
No, because this one's 99.
But then they deferred it,
this
and
is
then did
felony
they just
for
deal with it?
Oh, wow, so who's the other?
So she's out. So she's out. There's nothing that she can do with it.
I don't know.
Yeah, because once you have a felony, if you have no, it says no other misdemeanor felony.
All of the felonies are stuck.
So this is just.
Yeah, so what happened to that?
Okay, thanks.
So there's no conviction,
Yeah, but deferred.
but it's not a conviction, so it's not preventing it.
Those are just example petitions that I'm giving you guys, just so you can kind of look.
Forms look like.
So we totally have some questions.
What are those questions?
So, all right, our friend here seems to have two felonies. Only one is a conviction. And
But what do we do with the deferred?
Great
proceeding?
question.
you know more than.
We're gonna
I'm
take
gonna talk
what,
about
this?
deferred proceedings.
Oh, okay. Yeah, no, that's good.
Okay, so a really good question just came up with this record that you all are looking through. So this person looks like they were charged a long time ago with a felony larceny, was it?
Larceny by employee.
Larceny by employee. And this person went through something called deferred prosecution, and it was disposed of that way. So if you see that, what that means is that it was dismissed, but it was dismissed via deferred prosecution. So they were basically, what that means is they got put on probation and they did a bunch of stuff and stayed out of trouble, and then the DA's office dismissed it after a couple of years. So that is a great question. What that means is it still qualifies as a dismissal. The only difference is that it does come with a filing fee. So let's say that charge had just been dismissed like up front, the person didn't have to do anything, then they wouldn't have to do a fee waiver form. But this also, it still qualifies under 146 as a dismissal. It is not a conviction of any kind. The only difference is that they would either have to pay a fee or fill out an indigent fee waiver form to apply to get that dismissal expunged. Does that make sense?
Okay. Yeah.
So that's a great question.
Yeah. And at the clinic, there are these, I don't even know if the clerk's office, I don't think even requires us to fill out the fee waiver forms. They just waive all the fees.
Yeah.
So for your purposes,
Yeah, it's
it would
not
be the
really
same.
not relevant, but
So that then you can expunge all the dismissal.
But she can only get one credit.
Right, you only
you're
get
right,
one.
though, these are all fees.
What's the stuff?
No, if you expunge the conviction.
It's only one conviction, but it's only one conviction, but
So
then
what
we
you
get rid
need
of
to do
it.
is expunge the impoundment.
So that's the other question we have. So we have correction, but we could get the felony talk. Dismissal, then we have dismissal.
Oh, well, it depends on the year.
Yeah.
You think it's the most common?
Yeah, embezzlement, it has to be less than what, $100,000?
Yeah, so how do we know?
Sample
So
petition.
we would probably have to go pull the file itself, which is something we can do. The clerk will be there.
Oh, right, because remember.
My hunch is it's probably under 100. That's a lot.
Just judging by.
But still, no, we could pull it. We can pull it and find out. For the purposes of this, let's assume it's under $100,000. Just make it easier.
15.
Allegedly. Well,
Oh, was it today? Allegedly found behind
until
the
we expunge it.
Okay.
So then the first.
You can find out if you can get it
Alright, so we're
done.
assuming for purposes of
You
the
are eligible to get it
Oh,
done.
great.
Right, so if it is, then it's a class.
Violation of federal law.
Expunge.
Federal rule.
I think.
I don't know, this is fun.
Yes, you do.
Class H, okay, so nonviolent felony. Class H. Non-passive convictions got 10 years.
Except, wait, she has a proof of judgment, but it's traffic. So that's basically, then we say that's a conviction.
Yeah, so
Okay, just because of the time limit, does anybody want to, for number one, does anybody want to give us their opinion on whether or not this person is eligible for any expunctions?
We think that, well, so assuming that the embezzlement is a class G, or class H, so under 100,000, then we think you could expunge the felony as long as the traffic prayer for judgment doesn't count as a conviction. Which it shouldn't, right?
Right.
So you expunge the felony, embezzlement, and then you can expunge all the other dismissals, including the deferred prosecution.
Yeah, so I think that's exactly right. So on its face, we've got a felony conviction, and which would keep somebody from getting the dismissals expunged. But it looks like this felony, as long as the embezzlement is for less than $100,000, is going to be expungible under the general felony misdemeanor or felony nonviolent conviction statute. And if it is, then everything else is expungible, other than the prayer for judgment. So the prayer for judgment isn't expungible because it's a conviction, but because it's traffic, it doesn't bar this person from getting the felony expunged. Does that make sense? Because that for me was kind of the hardest thing to get used to. So you have to treat traffic differently because traffic doesn't affect your ability to get something else expunged. So this person has a traffic conviction. You don't even need to look at that and determine whether or not this person is eligible to get the felony expunged. However, it still is a conviction, so it is not expungible under any kind of statute.
And if the embezzlement were a class H, then no dice on any of it.
If the embezzlement was class
Sorry, if
C,
it were class C,
yeah,
then no dice.
right.
Except on the traffic. You still get the traffic.
And so so then we'd come back to the traffic. The traffic is expungible. It just doesn't affect your ability to get other things expunged.
Right.
It's not something you have to take into account, but it is. So a lot of times you don't want to get traffic stuff expunged because it's like,
That's your
okay, no license, or it's just not that big of a deal, and you only get one in your lifetime. But there are scenarios where maybe the person, that's all they've got, and they're in their 60s, and they want it, and maybe it's something that's a little more serious. I don't know. Then they do want to get.
You're like, are you
that
sure
expunged.
you're not going to try to rob your employer again? Because just want to
Right.
make sure.
Right. Yeah. So
There is a separate process that we can look at, even if you have a client there who has multiple traffic infractions that happened a long time ago, or so we have another project going on called the Driver's License Restoration Project. And so we are working with the DA's office on that too. So, if you see something like that, or if you guys see something like that when you're screening, I think we could take care of that in a different manner.
Okay.
That won't.
yeah.
Yeah.
So there are two different types of petitions that are going to need to be filled out for this. There's one, and do you want to cover that? Do it what? Yeah, so we'll file them at the same time. One is going to be a petition for the conviction, and one's going to be a petition for the dismissals. And you'll file them at the same time. We have the petitions with us. At the clinic, Darwin has basically a guide on how to fill them out. They are not very difficult to fill out, so we're not going to spend any time on that today. And if you have any questions at the clinic, then you can talk to us. I guess maybe we touch on it just a little bit. Really, the biggest thing is with dismissals, it's simple. You just need to do the petition. The only thing that might take more time is some people have so many dismissals that you're having to write every single one of them out. If it is
But that's it. That's all you need. You don't need, there's no filing fee, there's no additional forms, there's nothing. If it is a conviction that you're trying to get, that you're filling out the petition for, you need the form, but you also need affidavits. You need the petitioner to fill out an affidavit saying that like, their record is true and that they're in good character and
basically saying that they're like not a terrible.
Yeah, they're not a terrible person. And then they also need 2 affidavits from people that know them saying the same kind of thing. These are not things that they need to bring to the clinic. These are things that we will give them at the clinic to go out and get, and then they can drop it off at the clerk's office. The filing fee is something that would normally be needed, but with our clinic, it's waived by the clerk's office.
So basically, you just need to be like, have your antennas up kind of for any time a conviction's getting expunged. That person is going to have to go out and get some stuff and do a little homework, and we'll have all of that information for them and forms for them at the clinic. And then they'll have, usually we give them, I think it's like a week-ish to do because we don't want to hold up all the other petitions, but they'll just come back with it and drop it off at the clerk's office. Yeah.
Any questions?
How do we, are we just making a copy and what are we doing for service? Should I tune out?
They will be taking the petition. So if it's for dismissal and they can do it right then and there, the DA's office will literally be at the clinic and they're going to walk it over to the DA and they've been served. And it's the same process for conviction. It's just that they'll have to come back with some additional stuff. But the DA is that you don't have to deal with the service. They're the ones dealing with that. You'll just send them on over to the DA's table, basically. Yeah.
So I know that's a lot of information. The good thing is at the clinic, we're going to be there. Any questions you have, we'll go over it with you. And you also have an attorney that's already looked over the record. They'll have their opinion on it. So certainly it gets a little easier the more you do. And it's very rewarding to be doing it with someone that they're going to be over the moon, especially if they qualify for an expunction. So it's very rewarding. Any final questions?
Do we get these slides?
Yeah, that was definitely.
Yeah.
Yes,
So
and we're going to upload also like a couple extra slides for those people who couldn't be here in person today with like a filled out petition and all that stuff. So once we do that, we will send it your way.
yeah.
Definitely.
And then y'all are welcome to hold on to those packets. We'll have a ton more at the clinic too. So, but if you want to hold on to it.
Yeah, I would just flip through it at some point when you have a few minutes because there are some other categories that we didn't go into. The reason we didn't go into them is because they're very unusual and you're probably not going to come across a toxic vapors conviction, but there are just some things just to be kind of like, just to have in your mind that they exist. And it's a really helpful packet just in terms of showing you what the requirements are for each category, each statute. Yeah.
So just real quick, I know we're pretty much out of time, but I want to make sure we cover this just from a logistical standpoint. On the day of the event, you all signed up for different times. I know. I'll stand up.
Between the things.
Yeah.
Is this the mark right here?
Between the two.
Okay. So real quick, when you get there, there's a parking deck at the corner of 4th and McDowell Street, which is catty-corner to where the courthouse is. It's going to say jury parking. It's, you can't miss it. It's free to go in there. So go in there, park. Basically on the second level, you can park there. It's equal with the ground itself, so you don't have to go up and down any stairs. Park there. It's free to get in. It's going to be free to get out. After you park there, catty-corner from the parking deck will be the courthouse itself. So you just enter in through the first floor, which you'll see is the main entrance of the courthouse. When you come in, what I'm going to do is have a registration table for attorneys. So I have a separate one for clients, and I'm going to have one for attorneys. They both will be up front, but that way we can check you off to make sure that whatever time you signed up for, that we have the people there. All the tables will be behind you. You can pick your own table to sit at, whichever place you like to sit. What we'll do is the folks who are doing the registration for the clients, when the clients walk in, they'll get the client's name, they'll pull the record. If you're sitting there, they're going to come up to you and they're going to hand you a record. They're going to tell the client to have a seat. So we're going to have a waiting area. That's going to give you a couple of minutes to look over the record and the analysis sheet. Everything that you have in front of you, you'll be able to look over. It'll all be connected together. So analysis sheet and their actual record, you'll have. The analysis will already be done on that. You can just review that, see if there's anything else you have before you call them over. Once you've done that, you could then call them, because usually when a person walks over and say, here's this person's record, it's the lady there with the black and white dress. And so then when you're ready, you can bring them over yourself, or they'll help you by bringing them over for you. So it makes life a whole lot easier. Because we have a number of clerks that work with us as well, we're going to have some extra tables. So we know some people will have larger records and have more things on there. They may have more things to take off their record as well, which is a good thing. So to keep you all in rotation of clients, if you have someone with a large record where they get a number of charges dismissed, we're going to have some people who can fill out those forms for, so you don't have to sit there and do that. Short records, yes, that's on you to do those. When they're longer records, a lot more charges, then we have other folks, clerks, who will do those for you. So they'll fill those out, and then they'll kind of bring them back to you to kind of make sure that everything is on there, and then lead the client to wherever they need to go after that. But that way you don't have to sit there and write out 30 charges. I had actually one of my employees who was there last time, he had to write out 36 charges because he was able to get all 36 of them dismissed, which is a good thing, but not for my employee who had to sit there and write out all 36. So we wanted to make it a little easier for you. After that, once your shift is over, I think you check out with Sylvia. You'll get anything that she needs from you. And then just across the street, parking it, like I said, the arm will be up. So it's free parking all day. Any questions about the logistics? I think I don't want to speak for them, but sometimes they have snacks. We will have some water in there. I'll try to make sure that the HVAC is actually on before we start. The maintenance folks, they come in, but they may not always execute everything like they're supposed to. So it got a little warm in there last time, but we had nice cold water. So we'll have everything laid out for you. I'll be there. If you're missing a record, we have the ability, myself and the gentleman, Troy Hubbard, who runs the criminal clerk's office, we're actually able to go and pull a record right there in the courthouse because we have access to our computers to do so. So you don't have to worry about that. Any copies, we'll have those. Any additional copies, pens, paper, everything that you'll need to execute seeing all your clients, you'll be able to do that. Any questions?
I have a couple. So, and sorry if you just said this and I spaced out or something, but so like the one we were looking through, we actually had to like pull up our computers real quick and look up what the felony statute was to find out like, okay, what, and then it was like, oh no, could be C, could be H. But setting that aside, because I know you said we could look up those records. Is there Wi-Fi there or something that we'll be able to use to actually look up? I don't off the top of my head know what an embezzlement, what level of.
Yeah, so the courthouse has, and I know they're working their piece, but and they may, I guess, bring some of those, A through I. They may bring that. I don't know, but we do have court public Wi-Fi there. Good thing about it, we'll be the only ones in the building, so it should be running at a pretty decent speed at that time.
And also, I was just going to say, so in that sort of situation, like you're right to want to look that up because we want you to be, making your own determination, but on that cover sheet, when that person who had screened it in our office saw that charge, they should have written a class next to it. So again, I would love if you pulled out your phone and did a Google because it would just be helpful to have two people doing that. But those are typically things that we, have more access to and stuff. So that would say it.
Can we make some copies of?
Is that in the packet?
No, it's not in the packet, but I just have this in my bag.
We definitely could, yeah. Mm-hmm.
Just
maybe we should do that.
That'd be super helpful.
Yeah.
Yeah, we'll do that.
Other questions? Did you have?
Yeah, so in terms of the logistics, I'm actually flying in on a super early flight Saturday morning, and like I think it'll be way early, no problem. But the off chance the American sucks that morning,
I'll give
if I'm
you
a
all
few
my-
minutes late, no big
Yeah,
deal,
I'll
or-
give you all my cell phone, so you can text me or call me. I'll be the one, I can happily communicate with Darwin and let him know that an attorney is running late or, there's an emergency, things happen. So, our hope is to have enough attorneys to fill all the slots. And so, and then what actually happens on the day of is what happens on the day of.
Okay.
And so if clients have to wait a little bit longer, they will. We have separated, actually Darwin has separated the 158 clients into 3 separate groups. So 9 to 11 is one group, 11 to 1, and 1 to 3. And that's why you all signed up for different shifts. Some of you were kind enough to sign up for the whole day. We really appreciate that. And so, that's sort of the way it's going to flow. And so, I'll definitely give you all my cell phone number and you just contact me if something happens.
And then in terms of like dress code, what do people normally wear?
We had people wear whatever they wanted. You do not have to come into a suit. We were business casual.
Okay.
So
As long as you are someone will believe you're a lawyer.
yeah, but
I'm not sure I could wear enough.
courtroom attire is not necessary.
Any other questions for me?
Thank you.